Good morning. I'm going to be talking about GDPR once more. We covered it in September last year. There was quite a lot of interest at that point. This time we're going to be talking about SaaS and business sales. These are the points that I'm going to be covering. Broadly speaking, there are three areas I'm going to be covering. First of all, a refresher about what GDPR is, how it works, some of the basics that you need to know about it. I'm then going to cover subject access requests in a little more detail, which is the right that other people have got to know what you are holding on file about them. And then finally, I'm going to pick up issues arising out of business sales and common issues that you might be dealing with there. So let's start with a quick refresher about GDPR. 4 points I want to cover there. First of all, the background to GDPR and why we have it as a law of privacy. Then I'm going to move into looking at the degrees of confidentiality within GDPR, what the most confidential and what the least confidential material is. I'm going to be looking at the lawful bases for using data, because if you've got information on somebody on your file, you shouldn't have that unless there is one of these lawful bases for using that information, even for holding it. And then I'll be looking at privacy notices and how they fit into GDPR as a whole. They're particularly relevant when it comes to business sales. So here we go, a quick refresher on GDPR. It is a statutory law of privacy, and its purpose is to give all of us as citizens rights against organizations that hold information about us. And those can be businesses, small and large, charities, health services, government, all sorts of organizations. GDPR has become effectively international legislation. Its origin actually is the UK's own Data Protection Act 1984, which we exported to the EU, and we have since, until recently, been at the forefront of developing the protections of GDPR. A number of other countries have similar laws, particularly a number of American states. And the basic principle behind it is the idea that all of us should have the right, as individuals, as a human right, we should have the right to control information that other people have got about us. And when I spoke about this in September, I suggested that there is this golden rule to GDPR, which is that those who are running organizations should treat the information on others that they hold in the same way as they would like other organizations to treat the information that they have got about them. And I think if you follow that principle, you probably won't go badly wrong with GDPR. So to look at these specific legal obligations, these are some of the basic principles of GDPR. You should take only the information about people that you need to take. You should only keep information that you are allowed to use. And this next point is one of the things that was new in GDPR over our previous data protection regime, which is before you had to have the right to use information about somebody. Under GDPR, you not only have to have the right to use information about people, but you also need to have a written record of what your legal basis is for using that information. Consent in some ways is the most clear-cut way of being allowed to use information about somebody, but it's not the only way, and I'll talk about those a bit later on. Another legal requirement is that each organization should set its own policies, procedures, and documents for compliance with GDPR and should make sure that they follow those. And the third general legal point I'm going to raise now is that GDPR recognizes different degrees of protection. Some information is inherently more confidential than others and has a higher degree of legal protection to it. Another basic principle is the concept of the data controller, and essentially any entity typically a limited company or an LLP that has got a database about people is going to have to comply with GDPR, and that entity, rather than its officers or any individual within the entity, that entity itself is going to be the data controller, is going to have the legal responsibility for compliance with GDPR. Now, again, you can go back to the presentation I gave in September to refresh the detail of this, but as an insolvency practitioner, you are likely to have GDPR coming at you from 3 different directions. Firstly, as an appointment taking office holder, you are going to be a data controller in that capacity for some purposes, and you should be registered, notified with the Information Commissioner's Office for compliance with that. I understand that the ICO will actually accept a group registration from all of the insolvency practitioners in any given firm for that purpose. So that's the first direction that you're going to have GDPR coming at you from, is as an office holder, you're going to have your own obligation for compliance. Second one is that your firm itself is going to be a data controller for some purposes and will have its own obligations of compliance, which will be independent of those that you have got as an insolvency practitioner and office holder. And the third direction that GDPR is going to come at you from is when you take appointment as liquidator or administrator, for example, over a company that is itself a data controller, because the insolvent company will be a data controller. It will have its own GDPR obligations, both before your appointment and after your appointment. And as the office holder, you're not directly responsible for making sure it complies with its obligations, but you do need still to think about this. I'll say a bit about that in a minute. There are degrees of confidentiality. GDPR protects some information, but not all information, and it protects some information more tightly than others. So these are the degrees of hierarchy. First of all, anything that is not personal data. Personal data is any information about any living human being. That is personal data. That is protected by GDPR. If it's any other sort of information, it's not protected by GDPR, but you have to remember that that doesn't mean that it's completely free to use. You may well have other obligations of confidence for that information, perhaps professionally, perhaps contractually. Next layer of protection is for personal data. This is the standard GDPR protection, and any information about an identifiable living human being is personal data, and that is protected by GDPR. Next category I've got is financial and information data. That is not actually listed in GDPR as coming within a different category, but you can see that there is obvious damage that could be done if you inadvertently release identification documents that you've got or financial information about somebody. So you're likely to have your own policies and procedures for safeguarding that sort of information, perhaps a bit more securely than the legal minimum under GDPR. Next category is special category. It's particularly sensitive personal data, and this is regarded as being more confidential than the normal under GDPR. You will have fewer occasions when you're entitled to take it, keep it, or use it, and you have to be more careful about how you protect it if you have got it. And the final category, the most sensitive sort of information, is basically criminal records. I'll say a bit more about those last two. First of all, special category. This is particularly confidential information under GDPR, and this is really particularly personal information about people. It is a fairly close map to the protected characteristics under the Equality Act. There's the list there. I'm not going to read them out to you. And criminal records, information about crime, is even more highly protected. It is the most sensitive category. And this is important for you because you might well come across this in that it includes information about crimes that are alleged or under investigation. So in the normal work that you're doing, you may well come across something that looks like some sort of criminal activity by somebody. That is in the highest category of protection under GDPR. There are 6 bases, 6 legitimate reasons, 6 ways that you can authorize holding, taking, and using personal data. I won't say a great deal about any of these. The first one is if you have the consent of the individual concerned. Second one is a contractual basis. If you are performing a contract with that person and you need data to carry out your obligations under that, then you are taken as having the authority to do that. The third one, which is particularly useful, is legitimate interest. And that is one of the situations when you can use information about somebody without having their express consent to do so. To use the legitimate interest authorization, you need to have a legitimate interest, you need to identify it, and you need to show that you can, whether you having that data is necessary to achieve that particular interest that you've got. And you have to carry out a balancing exercise. You have to balance your interest in using that data as against the interests of the individual concerned to have their stuff kept private and to have their confidences respected. Next basis that you've got is to perform legal obligations. Again, that's going to be quite important for you as an insolvency practitioner, as being one of the ways that you're going to be able to authorize the way that you're using personal data. Another one is when acting in the public interest or exercising official authority is again useful and relevant, but it is actually surprisingly limited in its scope. And the last of the 6 is vital interest, which is basically as a last resort if it's a matter of life and death. Going back to the first of those and consent, the thing you always have to remember about using consent as the basis for using somebody's personal data is that they can revoke that consent at any time, in which case you've no longer got any right to use their data. And I said at the outset, I'll say a little bit about privacy notices. They are integral to the GDPR regime in that people are entitled to know if you are compiling a dossier on them, in effect. And so as soon as you start collecting information about somebody, you should tell them in writing why you're collecting information, what you need it for, how long you're going to keep it, who else is going to see it, why it is that you are entitled to keep a file on them, and a lot of other things as well. And strictly speaking, you should be issuing privacy notices to the bankrupt at the start of the bankruptcy, probably to members of the bankrupt's family as well. At the start of a corporate insolvency procedure, you should be issuing privacy notices to each of the directors and, in some cases, possibly their associates as well. I won't say very much about that because I want to get on to the 2 key points that are, if you like, the headlines of today. The first one is subject access requests. And this is the right that people have got to ask you to tell them what you've got on your file about them. 3 things I'm going to be talking about here. First of all, what rights people have got to see what you've got on your file. Secondly, if you receive a subject access request, how you should comply with it. And thirdly, when you're entitled to refuse to comply with it. So first of all, the rights of access. And this is the idea that when you are a data controller, remember this can be you as an office holder, when you're a data controller, people have got the right to know whether you've got a file on them, what is on that file, including copies of the documents that you've got, and lots of other information as well, which is broadly the sort of information that you should have in your privacy notices. And again, remember, as an insolvency practitioner, subject access requests can come at you from 3 separate directions. Firstly, as an office holder, where you are going to be a data controller in your own right. Secondly, people might ask for information that your firm is holding about them. And thirdly, if you're dealing with a insolvency of a business, then that business is itself going to be a data controller. You're not the data controller for its data, but nevertheless, you will have to deal with subject access requests that come into the insolvent company that you are dealing with. So if a subject access request comes in, how do you deal with it? First of all, check who is the data controller. Is it yourself as office holder? Is it your firm? Is it Bustco? Or it could be more than one of those. You have to remember that other people may have got rights of privacy over the information on your file. So if it's the bankrupt asking for information that you've got about them and you're thinking, well, actually, I'm quite happy to show them everything I've got on my file, you may not be able to do that because you might have information about, for example, other members of their family that they are not entitled to see. When a subject access request comes in, you've normally got 1 month to comply with it. You do have the right, and in fact, it's best practice to ask for ID first, unless you're already satisfied that the request is legitimate. You mustn't be heavy-handed about this. You've got to ask for enough ID that you don't give information to the wrong person, but you shouldn't be using the request for ID as an obstacle. But as long as you ask for it promptly, then the 1 month you've got for compliance doesn't start to run until they've identified you to your satisfaction. And normally, this is work that you have to do for free. You can charge the time to the case, but you can't charge the individual asking for the information for the information that you're supplying to them. There are some exceptions to that, but the basic rule is that you can't charge for it. Now let's look at what happens when a subject access request comes into the company of which you are administrator or liquidator. You are not the data controller. So if you like, in insolvency terms, this means that compliance with the request is an expense of the administration or liquidation, but it's not a personal liability that you yourself have got. And in the case of a subject access request coming into an insolvent company, there's no one-size-fits-all way of dealing with it. You are entitled to look at whether the cost of compliance is disproportionate, and if it is, you are entitled to say to the person making the request, I'm terribly sorry, I am not able to make funds available to the company to deal with your request. Here is a proof of debt form. Please lodge a claim as a creditor in regard of the company's inability to provide this information to you. But before you do that, you actually need to find out from them. So you probably need to pick up the phone, send them an email, ask them, what do you need this information for? And once you know what they need the information for, you can then assess whether the cost of compliance is disproportionate or not, because you can see, you can form a view as to how much damage will be done to them if you don't provide the information. If the subject access request comes into your own firm, I'm not going to say much about that because you should have your own procedures within the firm for dealing with that. And if you think the subject access request is addressed to you as the insolvency practitioner, then just check that this is information for which you are the data controller, and see whether actually what they're asking for is information from the company's own files or from your firm's own files, in which case it won't be your responsibility as data controller. Assuming it is your responsibility, then you have to think about whether they are entitled to the information that they've asked for, and you also need to think about whether you're willing to supply it. Now, you might be willing to supply information that, strictly speaking, they're not entitled to have. It could be a useful thing to do, but if you do that, you need to think about whether that might prejudice the rights of others and whether you might be infringing GDPR rights of others. Similarly, you might also prefer not to supply information that they are presenting you with a legitimate request for. Now, the fact that you don't want to supply it is not of itself a reason to withhold the information, but there may be a reason why you can withhold it. There are a number of specific exemptions within the legislation. Working out which one applies is quite a technical question, but broadly speaking, the sorts of occasions when you are going to be able to refuse to provide information is if you're in negotiations with them and providing them with the information that they have asked for is going to be prejudicial to what you are trying to achieve in those negotiations. Similarly, if the information is legally privileged, you can refuse to make it available. And this can be quite useful in terms of working with your lawyer if you think there is a risk of the bankrupt, for example, asking to see your file. If you can run as many questions as possible past your lawyer so that they are legally privileged, that may well help to protect the confidentiality of what you've got on file. If there are criminal investigations that could be prejudiced, you're entitled to withhold information. And there's another one which talks about prejudice to public interest work, which could include CDDA investigations and D reports. And you are entitled to redact information that you've released. So you might find that there are some documents that contains some information that they're entitled to see, and you might have to tip-X over the stuff that they can't see. Right, that's subject access requests. I'm now going to try and skate through business sales in the last few minutes before we finish. Three main things I want to look at in business sales. One is what sort of databases you might have. Second thing is what sort of things you might be thinking about on the first day of your appointment. And then the third question is whether you can actually sell the information in the database at all. Now, businesses will often hold several databases, information about employees, marketing databases, customer databases, supplier databases. And if it's a firm that's providing personal services, there will be working files. And the contents of those working files may well fall into special category, possibly even refer to criminal issues, as may the employee files actually. So you need to think about what degree of protection applies to those files. Other things you're going to be thinking about with those databases are going to be, where are the databases, for example? Are they in the cloud? Are they on a server that you've got control on? Are they on the director's personal laptop? Where are they? What licenses, software licenses, do you need to continue to have access to the information on the databases? Who's got the copyright in the software and in the databases themselves? Practical point, who actually has the access codes and passwords? Who knows how to log in and get the information from the databases? And who else has got copies of them, legitimately or unlawfully? And in amongst all of that, you're going to be thinking about GDPR as well. And as a practical point, are the records actually reliable? Are they of any value to anybody? And this then feeds into the issues you're going to need to be thinking about on day one. Can you actually trust the systems the company was operating to record and manage their databases? Do they even have any useful or valuable data? And if they do, are they registered with, or in the strict legal jargon for it, notified to the Information Commissioner's Office? If they're not, then they will not be lawfully using the data. And if you want to do anything with it in the insolvency, you ought to get the bus company notified to the ICO immediately. You need to think about how you're going to need to use the data itself and what the potential risks are if it goes wrong. How many people could be affected by some problem with it and how bad it might be for them. You may find that you're identifying things that you need to change now, and you may find that you're identifying things that actually need a little bit more investigation a bit later on in the administration of the case. And if you're thinking about trading the business for any length of time, these are the issues you're going to be thinking about there. What trading might you be doing? How long might the business be staying open for? What are the risks, looking back at those day one issues as well, and how often should you review those those issues, whether it be once a week, more frequently than that. And also, if your review has identified any changes you need to make, you need to get on and make those changes. Next question for you is actually, can you sell the data at all? And this is where those privacy policies become important. You're going to need to look at what the privacy policy says. A surprisingly large number of them say something like, we will never ever sell or give away your information to any third party. On the face of it, that is unhelpful. But you do need to read down into the privacy policy, because you might find that that's only a headline, and actually there's some really useful small print that does allow you to sell their databases. If there isn't, and you haven't got any authority for selling the information, you can change a privacy policy. And the way that you change a privacy policy is you have to tell all of the users that you're changing it, what the effect is. Ideally, you should give them advance notice, and of course they will have a right to object to the change. So if previously you weren't going to be selling their information, but now you need to as part of a business sale, you've got probably a legitimate interest in doing that, but they would have a right to object to that. Just as TUPE tends to be more the buyer's problem than the seller's problem, but getting it right can actually have a positive effect on how much you sell the business for, so is GDPR. And if there are GDPR issues with the database, then they're going to be much more of a problem for the buyer than they are for you in all probability. But sorting out those issues in the course of the sale can actually help to maintain the value of the databases. So from the buyer's point of view, they're going to be looking at what the privacy policy says. They're going to be thinking about how they're going to be using the data that they get and whether the privacy policy is broad enough for that. You will need to check that the buyer is notified to the ICO, because if they're not, you shouldn't be passing any data to them at all. And the sale agreement should deal with any irrelevant stuff in the company's records that is going to get passed across to the buyer. And the basic principles there are that the buyer should acknowledge that they aren't going to be able to use it and that they will have an obligation to delete it securely. And some of that also applies in advance when you're negotiating the sale, when the buyer is doing their due diligence. And in particular, employee information is something you are going to have to supply to the buyer. There are certain information that under TUPE you have to supply to a buyer in anticipation of a business sale. And the fact that you've got a legal obligation to provide it means that you are authorized to do so under GDPR. The buyer will ask for other information about the business. Now, of course, there's going to be a commercial imperative in not providing information to them that you want to sell to them. You don't want to give away stuff that you want them to pay for. But there's also a GDPR imperative in that you shouldn't be handing over any personal information to somebody who is merely negotiating to buy the business unless it is absolutely necessary to do so. And you're going to need to check that the buyer is notified to the ICO. You can check their registration on the ICO website easily enough and insist that they get registered if they're not already registered. You should have a good non-disclosure agreement which recognizes from the buyer's perspective that they have got obligations to the individuals whose data they're picking up as part of the due diligence process, and that they have obligations to delete any information that they don't need and which they no longer need. So that is very quickly through business sales and subject access requests, after having given you what I hope was a helpful refresher on GDPR. So if you have any questions and you haven't already asked them, please do so now. Let me just see if I have got any questions. Just bear with me. I don't see any questions. So no, but if you've got any questions that you'd like to drop me an email with afterwards, I will be very, very happy to deal with them. And I'll just mention a few important dates to you that you might want to jot down if you haven't already got them. First of all, our next coffee break briefing, which as I said is going to be on tenants in liquidation, is on Monday the 3rd of April. There is the R3 Southern and Thames Valley Forum in Reading on the 23rd and 24th of March, and I think they're still accepting bookings for that, but you'll need to be quick. Most important is our second annual insolvency conference on the 12th of May, which will be held here in Christchurch. It's not quite Venice for those of you who are weighing up whether to come here or whether to go to the R3 annual conference, but there will be a view across the river from the venue, so it should be a good day. Hope to see as many of you as possible at that. And I will be speaking at 2 SESCA insolvency seminars and their annual insolvency conference, which are on the 18th of May for the first seminar, 7th and 8th of September for the conference, and the 5th of October for the second seminar, and bookings for those are available on the SESCA website. And that is it. So thank you all very much indeed for your attendance. Goodbye and thank you all. And if you have got a question, please do drop me an email. There's my contact details on that final screen. Thank you all very much. Goodbye.